Thank you, everyone, for agreeing to join us on this Saturday afternoon. Really excited for this discussion on this important volume on IP debates in South Asia by Dr. Pratyush Upreti. We have Swaraj Baruha, who is our senior policy expert at Spicy IP and is an IP policy consultant, who will be introducing the book, and we'll also be talking a bit about his chapter on contributions by Professor Dr. Shamnad Basheer. And over to you, Swaraj. And after that, I'll introduce the authors and we can formally kickstart. Yeah.
Okay, so like many of the viewers would know already, this book is one of the first, maybe the first solid sort of cohesive attempt at looking at IP narratives from South Asia. As I understand it, there was an attempt to reach out to all the countries, but at the last minute, authors from a couple of the countries weren't able to send in. They had some other things coming up and they weren't able to send in chapters. Otherwise, as I understand, the whole of what is considered under South Asia would have been covered in this book. So for us, this is also for us, when I say us, I mean Spicy IP. This is also a special book because Pratyush, who was the editor for this, who brought together the authors, he early on mentioned that we would like to dedicate this book to Professor Shamnad Basheer, who is, as you know, our founder for Spicy IP as well. So for us, this being now that we finished 20 years of Spicy IP, 20 years since Shamnad first started blogging. And in fact, I mentioned a bit about what led him to start blogging in my chapter as well. He started in October 2005. And of course, 2005 is, as we all know, the year that TRIPS made its face known in India, and the various developments that have moved on, that have happened since then. So for us, this is a very special book as well, because it brought together, you can say, some of the approaches to thinking that several of us try to incorporate as well, which is focusing on context, right? So in standard academia, you'd start with a research question, maybe by doing a literature review, right? If you're doing policy or academia. So here, the opportunity, and I'm calling it an opportunity to write about Shamnad's contributions. Um, I call it an opportunity because generally when you look at the work, the body of a work that an academic or an expert has done over a period of time, you focus on the work itself. But as many of us who have worked closely with Shamnad know, it's a lot more than the external outputs that were part of the whole, let me use a Gen Z term, aura that he had, right? And I'll go back to that word opportunity, right? So it made me rethink what's the best way of conveying this to an audience, especially as as time goes by, we'll have more and more students who may not have had any direct interactions or indirect interactions even, to sort of convey what was that, and I use the word enigma in my opening line here of Shamnad. And what to me, the way I went about this was trying to do not a literature review, but what I started thinking of as a context review, right? So, what was the context in which even the fact that he entered law school in 1994, which very coincidentally was the year that TRIPS was signed, right? The WTO was signed. And then India being one of the few countries that took the 10-year grace period to implement and update our laws. When he graduated 10 years, I mean, when he graduated 5 years later, and then by 2005, when he was writing more and more about it, there was a lot of turbulence around the domestically, internationally. People are trying to figure out, what's the best way of going about this new mandate. And this was externally, if I look at the external context, right, national as well as international, there's a lot of so nationally, we saw a lot of attempts to balance various local interests. And there was a lot of participation, perhaps more participation than what we see now in politics of what comes out of that TRIPS agreement, of the IP laws, etc. Um, and there was a clear attempt to balance a lot of these different interests, right? At the same time, internationally, there was a very strong push for a one size fits all approach to thinking, right? And this is where we saw a lot of at that time, it was neutrally called harmonization attempts. But as we've seen through the years, it was more of a mandate, an attempted mandate to fit a certain view of IP, right? It wasn't just for helping interlink, helping interoperate. It was also to help impose a certain view of how IP should be thought about. And so that's a lot of also we'll see that echoed through the books and through the book in different chapters. So that was, like I said, the external context which existed when Shamnad was graduating and just after he had graduated from law school. I'll take this, I'll read out one bit from a paper that he had written, one of his most cited papers, incidentally. It was published in 2005, right? About just when trying to understand what was happening with these changes. I'll just put the last bit, and reference here is to the 2005 bill, which later became an act. The result is an act that attempts to balance the competing interests of a variety of stakeholders, including domestic generic medicine producers, the domestic research and development community, foreign multinational pharmaceutical companies, civil society groups concerned with access to medicines, and intellectual property lawyers. Although this delicate balancing deserves some applause, the unfortunate fallout has been a hasty introduction of provisions that go against the grain of time-tested patent law principles and are likely to provide excellent fodder for litigation. Right, so he wrote this in 2005, and we saw this is how it played out, right? And it's also where a lot of his work over the next 14 years would go on to focus. So in that sense, it was a very opportune time for academics, for policymakers, for thinkers in that time to dive into this turmoil that was happening and provide thought leadership. And as I try to point out, as I describe in my book, Shamnath was definitely one of those thinkers who used this. So that was a context outside. Now, the context inside is when he was looking at, and I use this example that he used to say to us, which was that what got him in this path of, as many would know, that he also started IDIA, which looked to address a lot of concerns which may not be obvious at first, but also mirror a lot of the problems that we face internationally and nationally as well, which is the lack of understanding slash respect slash acknowledgement of the utility, the usefulness of diverse perspectives, and how that can help build. It's not something that needs to be done for the sake of it. It's how it can improve things, right? So with the question that he mentioned as one of the triggering factors for starting IDIA was in a in a class where he was talking about the Plant Varieties Act. He had asked this question, right? How many of you have been on a farm before? And this was at a top law school in India. And no one raised their hands because the way the law schools are structured right now, very few people from, or rather, very few people from a certain section of society are the ones who are able to enter these law schools, right? So it's natural, so to speak, that this is the outcome that we get, where you have people talking about implementation of laws, and that's a small minority, and you have a huge majority who are living those laws or who are having to live those laws, right? So this pushed also uh, I mean, this also sort of represented I'll get back to that diversity framing, right? And I'll read out again just 3 points of how he highlighted this clash, right? If everyone goes to the same schools, watches the same shows, if everyone speaks the same language, everyone sees the world the same way, how can you expect real creativity to be born, right? So that is one framing. Another is, again, what I just referred to. Diversity is not about charity or benefactee relationship. It's about contributing and making a richer ecosystem that becomes more meaningful and makes all our lives better off, right? And then along similar lines, there is no one truth, and embracing different perspectives helps us find multiple truths as well as better truths, right? So this is some of the framings that in at least in our conversations had come out earlier, and I thought it was very important to sort of see this as a lens through which many of his activities eventually took shape. And to me, this context of the external turbulence that was happening ripe for opportunity, the internal need and desire to see let me use the convenient phrase, real diversity being exemplified. It was this sort of mix of things which led to a lot of the, it's not led to, but it's a useful lens to see a lot of the activities that he initiated, that he encouraged, and that he pushed others to also partake in, right? So, okay, I won't go further into the chapter, but just to sort of end on this note, he had formulated an acronym, CHAMPS, as values that would be very useful for IDI scholars and legal students at large to incorporate in their thinking and how they go about things. And I tried to use those values in describing some of the activities. He had done way too many activities to put within one chapter. Um, and I think those are, it's of course one framing, the multiple different ways you can look at this. But to me, that was a great sort of narrative to show or to indicate a type of thinking that would go beyond what is the normally considered the well-trodden path, right? So, and those champs, if I break it down, it's creativity, holistic thinking, CHA, altruism, M for maverick, being a maverick, having a maverick approach to life, MPS, problem-solving approach, right? And again, my chapter, it tries to break this down and see some of his activities through these lenses. The chapter is also up on SSRN. If you search for the name of the chapter, which is IP and Social Justice, remembering the contributions of Professor Shamnad Basheer, you'd be able to find it. And fortunately, the publishers have also said that after 6 months from publication, we can put up the published version as well. So thanks to the publishers, especially for that aspect. And with this, I think that's a bit of, I wanted to talk on the dedication to Shamnad and why it was so important to us. I think I'll now move to the main part of discussion today. And Praharsh, if you could take it forward from here. Thanks.
So thank you so much, Swaraj. And thank you for setting the tone of all the important issues that we'll be discussing over the course of this session. Diversity, the whole issue about how Global South was subjected to signing TRIPS agreement and how they were asked to disregarding their own realities, they were asked to agree to certain things which was supposed to be right, when you look at it from a Western lens or Western perspective. So this is the introduction was something which is very important, and we'll definitely see more detailed, in-depth discussion on this in the coming one and a half hours. So taking this opportunity, I'd like to introduce the fantastic set of panelists that we have here for today, and I'll be introducing them in order of the parts that they would be discussing with. So I'll start with Shama. Shama will be reviewing the first part of the book, that is on IP history and development. Shama is an LLM candidate at NUS Singapore. Her review will be followed by Akshat, who will be reviewing part two of the book on development in South Asia. Akshat is the founder and counsel at AASA Chambers and a PhD scholar at Cambridge University. Professor Ishupal Singh Kang will be reviewing the part third of the book on institution, courts, and practices. Professor Kang is an associate professor at Jindal Global Law School. The discussion, we'll have 20 minutes per panelist for sharing their thoughts, their views on the different parts that they reviewed. And then it will be followed by a combined discussion slash Q&A session. So with that, thank you once again, all three of you. Shama, why don't you go ahead and start?
Yes. Hello, everyone. And yeah, thank you so much to Spicy IP, Swaraj and Prahash in particular for this opportunity. So I think let me start by first maybe just talking about the title itself, because I'm sure a lot of people would be questioning, okay, why South Asia in particular? Now, that's something that when I was reviewing the book, it also struck me that despite pursuing like a master's and that too in, let's say, in an Asian country, the discussions that happen in class also in terms of IP are never very specifically Asian focused, right? It's always a very European centric lens. So when that was one realization that I had, and then which sort of prompted me to take particular subject, which is human rights with an Asian perspective. And there the discussion that started for that particular lecture was what is Asia really? And that kind of prompted this entire discussion that how there is sort of a geographical and political clarity when we talk about, let's say, EU, which kind of is, even if we know geographically what Asia is, maybe politically in the sense of socio-economic factors or cultural factors, Asia may not be very clearly defined in that sense. So that kind of brings to this 3 Ps that Professor Theolian talked about as to why an Asian perspective matters, is because of these 3 Ps, which is particularities, problems, and priorities, right? So these are very different when we talk about the Asian region, and the colonial history being like the overarching factor that kind of has defined and influences even today the approach towards a lot of things. So from that sense, I think this perspective of South Asian perspective into IP makes a lot of sense, and also very important because, again, there was another book actually, which was by Professor Liu, which is titled IP Laws and Regimes in Major Asian Economics. So there he talks about this term, which is cross-jurisdictional legal empathy, right? Which is sort of missing when discussions on, let's say, IP happen at a global level as far as the Asian region is concerned. And he says that's majorly because, let's say, the discussions specifically in the Asian region are not as much as they should be. You know, the number of Asians discussing about Asian perspectives may not be so much. That's back in 2020, I think, when the book was published. But that, I think, sets the context to why this book matters. And it's not just, I think, for IP, but when I was reading it, the kind of lens that it offers is something that you can relate it to various other discussions in today's contemporary times as well. For example, yesterday, actually, I was in this lecture, which was about creating an international human rights treaty for AI, right? So in that as well, when the problems are discussed, they are, again, very, very Eurocentric. Data centers, for example, in maybe the Asian region, raises a lot of questions about environment, about water, how much water consumption, so right to environment, right to water. These are aspects that an Asian region would associate with AI and AI-related problems. But interestingly, that does not come to the forefront. That is never a factor that gets discussed when, you know, the discussion on AI problems or solution to AI problems are done. So to me, I think this lens of looking at things through an Asian perspective is not just IP, good for IP, but I think it would also assist a lot of other contemporary discussions. So with that, I think talking about the first part, I would rather say there are two, instead of going into each chapter, I would rather, because the first part majorly focuses on Indian perspective towards patents and GI, if I have to divide it broadly. There are two themes that I sort of think that go through these chapters. One is the decolonial lens, of course, of looking at things, and then that also then gets to the next factor, which for me is very interesting. That is the hypothesis premise misunderstanding, I would say, which again has a link to how, all these factors influence of how we view IP. So let me just start by maybe getting into chapter wise and linking it to these factors. So the two chapters on patents, one chapter basically focuses on the Novartis judgment and the rationale of evergreening that sort of defined Section 3D's introduction post 2005. And the other chapter is looking at patent reports during the colonial and post-independent India, which were published. And the link that sort of binds these two for me is the entire perspective of looking at it. So as chapter 4, which is by Professor Shubha Ghosh, talks about whether when patent system, for example, was implemented in India, it was more of, I think the entire IP history as such, if I have to talk about it, is like 3 parts, right? One is an enforcement of a regime which was not designed for this society. The second part of it is where the countries sort of in this region try to internalize it. And then ultimately the third, I think, level would be where we are sort of now having a say in how global policies in this regard are to be made. So between the first and two, there is this tussle where something that was enforced and later when it came on to the internalization of it, was it that smooth? Was it easier to like just absorb it within the system, given that there is no, let's say, cultural, legal roots for, let's say, IP in general that can be found in this region. Something that, again, I think Devanshu points out in her chapter on GI, where she's talking about the sustainable development angle of looking at GI. So in that context, when we look at patent reports, it's clear that even though it was marketed as something that would help the region, the intent or even the objective when it was being brought in India need not necessarily be the same, right? It was more of, if it is to be seen, it sort of benefited the colonizing powers themselves. Which again, interestingly, in the chapter on the Professor Liu's book talks about, even in 2020, when he analyzed the granted patents in India based on the WIPO records, it turns out that there were less patents, there were less Indian patents as opposed to foreign patents, right? So that's again something that you see, the chapter also talks about, that maximum patents were sort of to help the colonizing powers, and they were mostly became means to, like, divert what he calls the technology obsolescence rather than a technological transfer as what was advocated. Which then, if I link that, so we see that this is how a system was enforced, which maybe somewhere justifies the kind of apprehension that the society as such would develop towards this, given that it kind of drove out a lot of traditional Indian producers, because they were made to compete with greater technology. So in all of this background, when we come to maybe the chapter on Novartis and where evergreening is talked about, I think you can sort of see where that fear of evergreening would come from. But then that itself leads to the next question, which the chapter explores, is should that fear, let's say, which is justified maybe in the history, should have been considered as a hypothesis or a premise, right? So a hypothesis is something that is rebuttable. You prove it, you disprove it. Whereas a premise, when you start it off as an assumption. So when so evergreening became like the narrative force for why Section 3D was worded ultimately in the way that it was, which sort of prevented the secondary patents of like similar forms unless you could prove the efficacy, etc. We understand the justifications for where maybe that came from, but then is it important to question these? Is it important to question these kind of justifications? Because even now I feel, if I'm to link it to the current AI and copyright report that is out, it again does somewhat similar misunderstanding between a premise and a hypothesis, right? It goes on to just assume things in terms of making its recommendations or forming a policy discourse, which then I think leads to a point where courts, which again are not functioning, I would say, in a vacuum. They are functioning in a global context where they realize that, okay, in the so-called multilateralism, where you have a lot of international treaties and bilateral, multilateral treaties which are being signed, how do you then sort of interpret these provisions which have been rooted in a particular kind of a justification? So I think it's very interesting to see how Chapter 3 then goes on to talk about the justification for evergreening, even though as how it was rooted, how the courts have subsequently sort of diverted, even though not expressly stating it, by rooting it into this theory of realism, right? Where there is more, they've always interpreted it, they've gone on to interpret it in a more practical sense, to look at, okay, what is it that is needed of this situation? And there are judgments where the distinction between, let's say, a chemical compound and a biological compound is brought about to say that, okay, this provision of evergreening was maybe Section 3D was maybe only in terms of chemical compounds and not necessarily biological. So I think in that sense, what these two chapters sort of interacted and emphasized was that it does become important as to how you justify your rationales. Because, I mean, to go back to the basics of how interpretation of statutes and everything goes, we do go back to these justifications to find ways later on. So the minute you, I think, strongly root it by giving it these sort of justifications, they do sort of shape your further discourse. And then you are, struggling with maybe this idea where you also have to account for the regional requirements, at the same time maybe balance it with your aspirations of trying to be, fit into maybe a global sort of a setting. So to me, that's the kind of interaction that chapter 3 and 4 had, which then I think the entire perspective of bringing the regional focus on Asia and why these matters then sort of again links chapter 5 and 6, which are rooted in GI. And the discussion that both of these chapters have is in terms of why a regional perspective matters, as to how there has been, as we started this discussion also, as that, when TRIPS was brought about, the entire idea of maybe universal was equated with uniformity, with no regard for the regional specificities, the regional requirements, which are influenced by a number of things, right from economic to socio-cultural to the kind of diversity that this region has. So in all of this context, when you want to enforce one size fits all kind of approach, where does that leave the stakeholders? And this then also leads to the second question of, when you have these kind of approaches where, the so-called the top-down approach, somewhere the relevant stakeholders are not being given the kind of platform that they should have. So, for example, the entire concept of terroir, and how there is a link between the human and environmental factor, but the human factor is never adequately addressed. And then, very interestingly, I think in chapter 5, Devanshi sort of questions that who gets to define sustainability, right? So the fact that these power dynamics exist, as to someone who's defining sustainability has the power to sort of shape the discourse. And then within that structure, I also have to fit in my interests. That I think also brings out a very, the entire power dynamics that exist within, I think, the lawmaking and even the policy structures. So where do then these narratives of how to then make certain things, like, for example, GI, how does the sustainable development narrative should then be driven in a more regional context, where you have, and there are specific case studies that she gets into about the Chanderi, and to just analyze how there is such a strong human factor, who being the important stakeholder, but do not have a say in how these policies are going to govern them. What was also interesting was that, to me, when we talk about the incentive theory of IP, which again is a very broad justification that is constantly brought forth for IP, to put it in GI context, you suddenly realize that it need not necessarily be really working, because there was a recent discussion also that Spicy IP had, where Niharika Salar was part of it. And she talks about how for Bela printing, there is just this one particular artisan who's now only left, who knows how to do Bela printing. So if GIs are supposed to be incentivizing the people, how, you see that now he's the only person and his family doesn't want to take forward all of this. So are the incentive, like, are these theories also really in the regional context, are they really working, or is there something more that justifies IP for our region? Maybe, I don't know, cultural heritage or tradition, respect for tradition. Because again, an interesting point that she made was, there is no, so even when these GIs do get like violated, the stakeholders are not interested in suing or pursuing any sort of litigation, but they just want to have like a discussion and sort the matter. Because for them, it's more to do with their heritage. Like, my forefathers have been doing it and I have been doing it. So for me, like, for them, it's part of their heritage. It's part of like the respect and reputation that they associate with it, right? So in that sense, then how is incentive theory also even working, or is it even working, is also a question that kind of, I think, that brought before me when I was reading that particular chapter. And that then very beautifully makes the segue into the next chapter, which is co-authored by Niharika Salar and Professor Pratyush Upreti, which advocates for these sub-national systems, which are designed in terms that they cater to more regional specificities, right, from economic resources, how they are allocated, what are the needs of that particular geography, what are the conditions of that particular, what is the demand, right? So you sort of try to bridge and align what you have to offer with what is really expected by the stakeholders for whom this law is supposed to be benefiting. And it draws on to talk about how now in specifically in the Asian region, you have a lot of national IP policies that are coming up, which again very specifically focus on the national needs that exist. So to me, I think these two chapters very beautifully interact in the sense of where one raises the question, the other sort of does try to answer it by saying that, yes, maybe, the stakeholders that we are talking about who are not adequately represented can be given this platform through a solution that could be this kind of a system, which rejects the top-down approach, which is something that has constantly been, enforced or advocated for, and looks at maybe sort of a bottom-up approach. And as much as all of these discussions do bring forth and offer solutions, I think personally, when we do talk about, let's say, the subnational kind of approach, I think even then within the Indian region as such, there are so much more factors that could decide its fate, and which again, the authors do acknowledge. One is obviously corruption, but I think even gender representation, right? It's also a chapter in the later parts of the book. But how do these factors like gender or even the caste system or these kind of things, and how then are we going to navigate that to ensure that their interests are also represented by whoever will be given the, whoever will be representing. So yes, indeed, I think, so in that sense, I think it is interesting to see that instead of just constantly being told that, okay, this is good for you and hence you should follow this, now the arguments that the book is making, let us tell you what is good for us, right? This, I think, because we are in a better position to understand these diverse factors, and hence there is that shift of approach, and the solutions also sort of cater to this necessity, because I think that again, something that was said, that it's easier for us to, because being from the region, you are more well versed maybe with the specificities and the factors that sort of affected. So again, it was very interesting that it was in a chapter which was authored by Latif Matima and Stephen Jamar, where they talk about how any perspective that sort of helps someone gain a fresh perspective on what otherwise may be so well known as to have become part of the background and therefore all but invisible is something that's valuable. So to me, I think the whole of part one can just be summarized in this, that it does offer a new perspective. It offers not just, I would say, it does raise questions and to an extent maybe answer them, but it also opens this segue of raising more questions and maybe developing new approaches that lens not only is limited to maybe IP, but even all other contemporary sort of questions that are coming up in today's contemporary times. So I think, yeah, I think for me, I'll say this much. And
Thanks a lot, Shama. Really, one thing that for me, while you were describing the first part, the book basically rattles the cage of status quo, which is usually people looking at IP from a very Western perspective. And you rightly summed it up that, instead of doing that, what what these chapters do is they ask you to take a step back and be like, all right, fine, we are staying here. We are the ones who can actually tell you how or what sort of law do we need to have in place to make sure that things actually work out for us. So, thank you for putting it so nicely and for explaining it in such a nice manner. One thing that I did take away is that it raises a lot of important whys. Why sometimes, in order to just being told that this is how things are supposed to be, we forget that we need to go back and start questioning why this is something that is good for us. And that is perhaps what the first part does. They try to they tend to raise a lot of important whys and hows from a global south perspective. So thank you for such a great and beautiful explanation. Uh, Carrying on the discussion forward, I'd like to call on Akshat. Akshat, why don't you go ahead and start with your thoughts on part two of the book?
Thank you. Thank you so much, Praharsh. I hope I'm audible. Just to take a moment before starting, I'm very excited to see Professor Ishupal here. He was my professor at Jindal, and he was the one who actually taught me international IP for the first time in my fifth semester, which led me to meeting Swaraj and then to meeting many others in such history. So crazy to be here with Professor Ishupal on the panel. So I think Shama's introduction to the book and the first part of the book was a very good segue to what I want to talk about. And it actually shows as to how part two of the book also builds on the thoughts that are in the minds of the authors of part one, especially the idea that Shama sort of concluded with, which was, let us tell you what is good for us. And, the part two stands out for me because, there are aspects of chapters in part two that are not just argumentative, but also very informative. I mean, there are workings around the law that have been done by various jurisdictions, and I'll get into them in the course of the talk, that ideally we don't see elsewhere. And that shows the local context and also puts on the table certain alternates to the Western idea of intellectual property that is often driven by various economic concerns. And so the whole scheme of part two basically describes how various Asian jurisdictions have tried to incorporate and sort of implement the mandates or the have-tos of TRIPS within their local laws, while preserving, to some extent at least, to the extent possible, the sanctity of their own cultural or social sort of situation, right, or context. So again, the context framing really sort of walks into part two as well, because it's all about context, right? Every author in part two is talking about how in their own jurisdiction IP is sort of regulated in terms of drawing from TRIPS because of the mandate, yet sort of working around it to fulfill your local needs in at least the way possible or permitted by TRIPS flexibilities. All the authors in part two also, have a common theme, maybe apart from the Indian piece, where they talk about the mandates of TRIPS. They talk about how they show a dissonance between the values underlying TRIPS and their own internal sort of cultural consciousness, or and just to sort of be an exemplar of how the thinking is very different, which is prevailing in these social constituents as compared to the social constituents from where TRIPS have actually originated and been imposed upon these sort of jurisdictions, right? So just to jump into the first chapter of part two, which is basically Nazima Kamardine's chapter on Sri Lanka, I think the most important part that I found, the most informative and the most interesting also for me part that I found in this book, in this chapter, was her talking about the protection or the sort of, the mechanism of regulating folklore in Sri Lanka, where she talks about how the Copyright Act in Sri Lanka provides for folklore protection not to individuals, but in a regulatory manner through the Director General of the National Intellectual Property of Sri Lanka. And this is like a regulatory right where anyone who wants to use a particular folklore expression would have to apply for permission to the Director General of the National Intellectual Property Office and pay a certain amount of money, which will then allow them to use that. And that money paid will not be given to any particular individual, but will be used as a cess of sorts for cultural development of that particular folklore tradition. This is actually very different from how we understand IP as an commodified unit of protection that is being given to a particular individual who is supposed to be incentivized or enabled through protection, right? So it's very interesting to see this alternate model, which can actually help reimagine IP across the world, right? If it's not about individual sort of enablement or incentives, and more about basically allowing cultural proliferation or securing culture, then how does an individual commodified mechanism help? And this sort of gives a different differentiating pathway to get into that, right? So this is something which I found really interesting in this chapter. That apart, this chapter also talks about how, a lot of Sri Lankan knowledge, for example, the knowledge of Sinhala craftsmen or knowledge of medicinal plants that was very prevalent due to the scientific sort of proliferation in Sri Lanka in the early 1600s and 1700s, were actually appropriated, again, in the sense of, due to the lack of visibility per se, right? So Professor Nazima gives an example of a cross-slot screw, right, which basically was used by Sinhala craftsmen in 1680 AD. But in the more recent patents that have been filed by Americans and even people in UK over this particular technology, they have not acknowledged this, nor has this been treated as a prior art, right? So the whole point which she tries to make is similar to what Richa Nagar had once made in one of her chapters called Hungry Translations, that knowledge claims of certain people make or render certain other knowledge claims quite invisible merely because of the ability to make visible and nothing else. That again shows the power structure involved in IP protection. It shows how power drives or visibility drives, and of course, power and visibility are quite connected to each other. So how that drives the idea of who gets protection of a commodified unit. So that's something very interesting. She also gives one more example of biopiracy, where a very prevalent Sri Lankan medicinal plant has been sort of used for a dental caries prevention sort of medicine in Japan and has been patented. Again, using this as an example of biopiracy. So what I'm trying to say is that part 2 uses these jurisdictions and examples within to show the base that has been set by part 1, interacting quite well, because part 1 talks about how there is sort of a mandate and there is delocalization of context, and part 2 shows how, right, and also shows its implications on that particular jurisdiction. So I think a good connect to the Sri Lankan chapter is in fact the chapter on Afghanistan, which is towards the end of part 2 of Awal Khan Ahmadzai. And in his chapter again talks about how Afghanistan has very recently incorporated IP principles within its jurisdiction and has struggled, especially because of the conflict between the norms of Sharia law or Sharia principles with the idea of a commodified unit of knowledge being sort of, marketed out, and that being the subject matter of intellectual property protection. So he talks about how, knowledge dissemination as opposed to concealment has always been a very virtuous part of Sharia tradition, and how copyright actually challenges that. And unless you actually implement these copyright norms that are prevalent across the world, it's like a trade-off choice that's prevalent in Afghanistan, right? In his narrative, there's a trade-off where you have to choose between furthering the social contextual values that are embedded in your tradition or your, understanding of society, as compared to development. So it's a trade-off. Either you choose to globally be developed or globally be sort of prosperous and globally survive economically, or you sustain your cultural embeddedness or cultural sort of significance that is inherent to you. So this dissonance is very well shown across the part, and more specifically in the case of Afghanistan. He also talks about how Afghanistan has implemented a Copyright Act now, only in 2016, only in 2008, but after the implementation, after accession to WTO in 2016, it's become a little more prevalent. Yet, there is very less implementation because people are unaware. It's just dissonant for them, intuitively dissonant for them to sort of enforce these norms, right? It also, this again brings into foray very, very concretely the dissonance that is there in these imposed norms and these embedded inherent norms in localized sort of Asian societies. Another interesting chapter that sort of I found very interesting was the chapter on Pakistan, right? Because the narrative of Pakistan that has been sort of curated by Muhammad Zahir Abbas and his co-authors is again one that it's also compared to India and shown how India is doing a lot more in terms of flexibilities as compared to Pakistan. But it still shows the problems that even we face on a daily basis. Like every year we are on the watch list. So is Pakistan, and so is the the effect on their own internal sort of already, as he says, there are already so much safety concerns within Pakistan, and they all get exasperated because of the economic mandates that come with these norms. Which again, he sort of draws this to show how the whole medicinal industry in Pakistan is suffering because the way they used to function sustains right now. There is lack of regulatory approval of drugs. There's a growing sort of concern around the medicinal quality. Yet, because of patent norms being sort of put out and there being no practically usable exceptions available because of the USTR report along with the weak compulsory licensing mechanism, it becomes very tough to do anything about it. So he also comes from a place of showing sort of, incapability to an extent. Like, what do we do about it? It's just very tough to do something about it because you're actually caught in a vortex where you just don't know of how to find a solution. Because there are mandates, there are political concerns, there are economic concerns. You have to balance all of them out while protecting the basic public health of the local population, which you're unable to, essentially. So that's also a very revealing chapter, in my opinion. The chapter by the editor of the volume, Pratyush, talks about trademark litigation in Nepal. Again, bringing a very interesting perspective over here as well, because he talks about how Nepal, in a mandate towards graduating from the LDC category of development that has been categorized again by these imposed norms, has codified intellectual property as a fundamental right, going a step above most of the other jurisdictions, right? So they have made it a constitutional fundamental right where the right to property includes within its definitional purview intellectual property. Again, in quest of being able to satisfy those who will enable Nepal to graduate from the LDC category. So again, in quest for so-called acceptance in the overall scheme of things, without appreciating the local context. So he talks about how judiciary is sort of safeguarded, at least to this in the trademark context, in this particular area, because they have tried to read confusion in a narrow manner, allowing multiple different products in even the same class with similar names to survive, so long as there's no confusion that actually comes to the mind of the judge. So it's, although indeterminate, yet a solution through the judiciary towards aligning their law with their local sort of concerns and policies as against just following the mandate. The other chapter, which is the second chapter in part 2, is a little different. So that's why I kept it for the end of the chapter-wise discussion, which is Professor Arul Skaria George and Varsha's piece, and that basically talks about the copyright and AI debate in the Indian context. They talk about how they think that India's statutory sort of law on copyright and its exceptions are very indeterminate as of now and are narrow, and they need to be broadened by changing the statutory sort of understanding of the exceptions. They propose a broad fair use provision in addition to a fair dealing provision that already exists, and also sort of propose addition of an explanation that basically is the 4-part test of fair use in the US minus the effect on the market test. So only a 3-part test, right? So I think their proposal is also interesting, and the only suggestion I would have over there is to complement it with curtailing the scope of rights itself and focusing on curtailing the scope of rights itself as against drawing on and building on indeterminate exceptions towards the back end that may not matter if the scope of rights are itself sort of narrow. And that actually is prevalent in the local Indian context, because under the Indian Copyright Act, technically speaking, the adaptation right is much narrower than the American derivative works right, and TRIPS allows for that, and so does Byrne. So that way, I think the focus over here is complementary in terms of curtailing scope of rights along with exceptions. So the overall theme, actually, from this part of the book, for me, has been a theme that has sort of been taught to me by Professor Ishupal and Swaraj and many of you over the years, which is most accurately sort of described in Susan Sell's book, right? Private Power, Public Law, where she talks about how TRIPS constraints are a systemic result of the proliferation of capitalism around the world, where a commodified unit is considered to be the source of any kind of sustenance. And so market exchange has become the norm, and participation is the only way to survive. Right. So the idea of allowing jurisdictions to calibrate IP policy or any innovation policy, like we saw in Sri Lanka, a different innovation policy that will suit their local needs, has actually been completely sort of wiped out by this TRIPS mechanism. And that's quite revealing, because it's showing how most of these countries who are actually now imposing norms themselves grew into IP gradualism, right? They only gradually adopted these broad and strong property rights over the years, as against doing it immediately, right? So the whole narrative around this part is showing the constraints coming out of something which they used to do but have not done for the countries that are now struggling because of these constraints out there. Yeah, that's about it.
Oh, great. Thanks a lot, Akshat. Continuing what I was saying early on, that it adds on to the point where we ended Shama's discussion, that it says or explains why we are the best people to tell what sort of thing is going to work for us, and explains from different countries' perspective as to what and how and why the imposed norms are not going to work. So the best part for me from this discussion is, and I would like to thank you for it, is by highlighting both things that the global south has adopted, by citing the example of Nepal and Sri Lanka, and explaining that why they have their own mechanisms in place towards administering and enforcing IP rights, and why this is something that has been working out for them, while also highlighting the challenges which are being faced by economies like Pakistan and Afghanistan, and why those imposed norms are not really going to work out for them. So I would like to thank you for putting it out and explaining it in such a nice and comprehensive manner for us. On that note, I would like to invite Ishupal for discussing the third part of the book. Over to you, Professor.
All right. Hi, everyone. It's so wonderful and also really bad to follow such detailed and rich kind of discussions by both Shama and Akshat. Good, because I think a lot of things are already on table, and so you feel like the discussion is already going on. There are a lot of intersection between both of their points. I would also have to add to it. And the bad thing is, I'll try to be brief, and I'll try not to repeat most of those things and err on the side of being boring. Okay, so to start with, part 3, the writings in this part, which consist of 5 chapters, and this part is titled Institution, Codes and Practices. And just like the other parts, they go through a span of themes, perspective, and approaches on issues and matters, and offers a kind of a richness to these issues and subject matters. And these issues and subject matter, just to put them together, range from an expansive reflection on the issue of gender disparity, which I think Shama already kind of foreshadowed in IP, to familiar concerns of access to fundamental resources like learning materials. And again, Akshat was talking about this, perplexities of complying with international patent standards in these dying days of the multilateral trade system, which has a history of, as Anne Orford calls, broken bargains, right? And then the part also moves to very important self-reflective questions, which are already, I think, coming. We have been talking about what kind of expertise, knowledge for whom and whose knowledge should matter. So the part ends with these very important self-reflective questions on politics of IP expertise itself. What is the IP field, and ostensibly what gets left out from this discourse. The first observation that I would want to make for part 3 is that there is a certain ease with inclusion of traditionally non-IP concerns. There is a kind of an indiscipline which does feel that a lot of other things which sometimes get left out can also be discussed with these IP things. Rather than taking each chapter individually, I'll try to see what are the commonalities and what are even the disagreements between different parts, different chapters, and even sometimes the same chapter. And I think that makes for an interesting reading and certain interesting broad themes which have already been mentioned. Colonial histories, who gets to make what kind of laws, incentive access framework has already been mentioned. So I'll try to organize my thoughts around these 2-3 broad themes. And again, I think as Shama started with this idea of the South Asia, I also take my cue from this fascinating subtitle that you find in the first chapter by Pratyush called South, and then Asia is in parentheses, at a crossroad. And I was intrigued by this formulation, why Asia is bracketed while South is there, and of course, crossroad. And in my own close reading of this, it seems like a helpful characterization, which already we are talking about, that there is a sense of Southness, which is, I mean, however we want to define it right now, that is concrete, significant, and of common concern in all the chapters, as compared to the bracketed Asia, which leaves it provisionally open, like in terms of geography, like rather than making it geographically and conceptually fixed. And I think this is supported by this very insightful foreword to the book by Dev Gangji, which does lay emphasis on questions of social justice. It talks about stark inequalities in sharing the gains and losses from the IP system. More importantly, for the need for examination of normatively preloaded assumptions, which we have already, I think, started talking about, and reimagination that go beyond the conceptualization of what he calls liberal individualism. So building upon these very relevant points, my first broad theme would be this exploration of innovation-centric perspective that is there in part 3. Although all the chapters do emphasize issues of equity and social justice, similarly as we have already seen, one can still feel that there is an undercurrent which is discernible at certain places, which can be called as innovation-centric perspective. And again, this relates to what I think Dev Gangji is trying to like sort of point out in terms of normatively preloaded assumptions. I'll give you a few examples where I could like sort of see it in the book. For example, there is reference to the Global Innovation Index and this assumption that it has a direct link with national IP policies and also as a barometer of progress or innovation in economic development. Or the assumption that introducing legal norms, intellectual property norms and policies would directly lead to improvement of women's life as diverse as authors, farmers and farm laborers actually, and traditional artisans. And also on a broad level of the notion of balance, etc., etc. This, of course, is a central aspect of the discourse or field, as the last chapter by Lokesh Vyas kind of reminds us. And he puts it like that: the IP field had solidified within a specific epistemic framework. And this is of course, something we all sort of wrestle with, work within, and so on. And on a pragmatic level, offering solutions within the internal logic is of great value. However, examining and questioning of these assumptions could also let us kind of break new ground, see things in a different way. I don't need to repeat that critical and interdisciplinary scholarship have sort of already documented what we all know now terms as ratcheting of IP standards, commodification of knowledge and technology. But what is more noteworthy and from a limited viewpoint that I would like to sort of put out is that the straightforward linkage between intellectual property, innovation, and progress and development as a horizon value has also come under scrutiny in recent times. So it's not only about balancing incentive access, but also questioning the values of innovation and even progress development and so on. For instance, as Jessica Silbe notes in her book, Against Progress, Intellectual Property and Fundamental Values, intellectual property law is no longer about promoting progress of science and the usual arts by simply granting to authors and inventor a limited property right. And this is important. The quality of progress and the characteristic of property are both under reconsideration in the digital age. And then she says the casual collection of IP progress is either much more complicated or built on faulty assumptions, right? So that's there. Similarly, Roos Khan, while talking about this link between IP, environment, climate change, and so on, in an appropriately titled article called Is IP Good for Our Planet?, points out that there is no reason to settle for an IP system that is unambiguously pro-technological innovation without critically reviewing its impact on continued destruction of our planet. And something which I have been sort of looking at, even scholars in different fields which have to do with questions of knowledge, technology, innovation. For example, science and technology studies, critical political economy, even some scholars of critical IP, have shown in detailed and compelling ways that even if IP is conventionally and theoretically about balancing of incentive and access, in contemporary global economy, IP has come to be predominantly entangled with processes of assetization. So here, I think Keen Birch and Muniza's book on assetization is very interesting because it says that the central organizing principle of our economy is moving from commodities to what they call assets. And this shift is very important to understand rentiership, all of that, and so on. So IP has come to be entangled in these processes of assetization, speculative finance, which serve the interest of financial actors without offering any broad material economic benefits to the society at large, right? So even if we assume the price mechanism or market mechanism, it seems to be not working in many of these things. Victor Roy's book Capitalizing Cure comes to my mind, which shows the link between patent law on sophosbir and financial extraction. So I think that book does a very good job of bringing both these things together. A refreshing and hopeful experience while reading this book was that the writings of part 3 itself offers a solution and offers interesting directions which aligns with the considerations and concerns and issues that I just mentioned above. For instance, there is a remarkable reference to empirical and evidence-based interrogation of fundamental normative assumptions in Gargi Chakrabarti's writing on gender and IP. And she puts it in a very interesting way. An important doubt remains whether the women involved in the production of geographical indications are actually receiving economic benefits of GI protection, right? So we need to interrogate this question of the link between gender consideration, economic benefits, and intellectual property regimes. Similarly, while outlining the suggested approach for a national IP policy for Sri Lanka, Altaf Marsouf stresses on the value of preservation of sovereignty and autonomy, which we have already kind of found. We have found as a thread which also runs in other parts of the book, echoing the concerns with uncritical adoption of expertise, legal, economic, otherwise. As well as he talks about substantive community engagements, discussion with the interest group, something I think which Swaraj was also mentioning, that somehow that has I think there has been a certain, I'm not very sure, I'm just making it because it comes to my mind, a certain depolitization on that, and we can have a conversation around it. And going beyond this, Lokesh Vyas in his prescription for a move towards decolonization, which we now know in current political climate everywhere is a fraught term, but I think the way he has used has avoided that fraughtness and kind of offers exciting suggestion. And he suggests that IP education training, the foundational elements of IP must be taught within the country or region's broad social, economic, and cultural context, adding a multidisciplinary perspective from anthropology, sociology, linguistic, etc., is extremely important, I think. And to conclude this point on innovation-centric paradigm, which also relates to the question of legal pedagogy, what kind of materials we use in class. One of my favorite and most useful in-class reading text to discuss with student is this blog post by Shamnad, which is titled "Obsessing on Newness, Death of Patents," which in a very playful and a lively way enables students to actually think about this foundational critique. What is actually new? What is the value of newness, and so on. So I always use it as a handout in class. I've also been thinking something which I recently heard Sundar Sarukai say about metaphors. He said metaphors are not only poetic, but they also order reality for us. So should we think of new metaphors of IP and what could these be? Where could these lead? And I am mentioning this because I read a very small but very interesting blog post by Tina Zawala. She's a professor of international law on LPE blog, where she's talking about tariffs and all of that and so on, but other regulatory policies also. And she's using Veblen's idea of economic relations and so on. But one metaphor which will kind of stuck from that article is this idea of sabotage, trade policies as sabotage, and she uses at many places in her article intellectual property policies, especially trade policies, TRIPS policies, as some kind of managing sabotage internationally and so on. But again, the value of looking at the same thing through different kind of lenses might also be useful. The second broad theme that I think is worth reflecting upon, which already has been mentioned, this notion of relationship between IP and historical narratives, right? We always refer to certain kind of histories, use certain kind of examples from history. So the uses of history around knowledge, technology, economic dynamics, etc., and their value in framing issues in contemporary time. And I'm raising this because there is a connecting, none of the articles are essentially a historical approach to IP, but I think at least 4 articles out of 5 refer to a certain kind of historical narrative, right? A certain kind of history to reach to the problem. And again, These historical narrative, at the risk of oversimplification, sketch the evolution of norm rules around production, access, and valuing of knowledge from pre-colonial times to the imposition of intellectual property rules and norms aimed at vested colonial interest, and then to the post-colonial realities. This, of course, is valuable, and it decenters, again, to use Dev Gangji's term, Western reference points. Shama also kind of mentioned it. And it ties up well with what we generally see historical perspective within our field, right? Whether it is the foundational article by Ruth Okediji on international relations of intellectual property, or this recent book by Amaka Vani, Patent Games in Global South, which is a 12 historical perspective on patent globalization, right? But like this importance for colonial, post-colonial historical narratives in these writing makes me wonder if this also opens up space for other kind of historical narrative. Is this the only grand arc that we can sort of think through, or there could be other kind of historical narrative which could complement the colonial, post-colonial framework by also including histories of resistance as well as histories of agency of the so-called colonized, rather than only colonial dominance. And I'm saying it partly as a note to myself also, because I get this sometimes, that you're too deterministic in your historical like sort of narrative. So just to like sort of flag that also, and also unpack the monolithic national or regional identities, because there are definitely internal tensions within what we can call South Asia, and the gains and losses even within this region are grossly inequitably distributed, which again we have kind of in other chapters with juxtaposition of different countries have kind of picked up on. Here again, there are interesting parts from the writing in part 3 itself, which offer glimpses of what this could be. So the chapter on Sri Lankan history on access to education, the debates around implementation in Sri Lanka of Plant Varieties Act, as well as references to the role of public organization and discourse in the educational access movement revolving around Rameshwari photocopying is there. It could be, I think, it could be much more central, but yeah, I think these points are there. Moreover, another point why I think I thought about this was the recommendation by Lokesh Vyas in his last chapter, where he says that the discipline of intellectual property, international law has, in terms of pedagogy, in terms of thinking about decoloniality, intellectual property scholarship can learn from international law. And international law has had a very interesting historical turn in last 10-15 years. There is a lot of work on history of the discipline and genealogies and so on. Right? A tentative suggestion in this vein would be Rosanna Machado's book, Counterfeit Itineraries in the Global South, The Human Consequences of Piracy in China and Brazil. This book offers a very detailed and insightful anthropological account of commodity circuits in the geographies of the Global South and how these interact with IP rules and regimes. It's not only an account of alternative globalization, but also how it interact with what. So maybe also take seriously the histories of what escapes the lawfulness of the IP field itself, right? So what's there? So this book, I think, paints a very interesting picture of issues of production, access, value, and also punitive dimensions of knowledge economy, right? That also is there. With this, I'll stop. Thanks again for this lovely opportunities to like read, respond, and like have this conversation on these very important issues with all of you. And I think big congratulations to Pratyush, the editor, and also the writers for these ideas and effort and putting this together and bringing this out. Thank you.
Thank you so much, Ishupal. One thing that really stood out for me during this presentation was how nicely the ideas, the thoughts which were expressed in this part were connected with a lot of other important secondary readings. And basically, for me as an audience for this of this panel, I came here to know a bit about this book, but after attending your session, I think I have a long list of readings which I'll perhaps take out and sit and read in context of what you explained. So really, thank you so much for doing that, and thank you again to all three of you for taking out time on a weekend to sit and discuss on this important volume. We'll be moving to the questions that we have by some of the listeners and audience members on LinkedIn. And after that, I'll open the floor for some of the questions by the panelists in case you guys want to discuss anything.